Today, I'd like to talk about the patent reform that is happening in 2014. Through the article from Patent EO and some research I've done online, I would like to briefly explain what this innovative act is doing with the patent. So there will be five main points that I would like to talk about. The first one is that they would want the plaintiff to be more specific about any particular lawsuit case because it used to be the case that um, a plaintiff can actually say things like, "Oh, this company infringed my patent, so I would like to file a lawsuit against them." But they don't want that because that's bad, and so that's why they wanted to be more specific about the cases. And the second one is that they want to make the patent ownership more transparent. So for any party that is interested, having financial interest in this any particular patent, it needs to be accurately documented so that they cannot form a shell company to hide behind the shell company. So this process will be more transparent to the defendant as well. The next one is that losing plaintiff needs to pay the legal fee for the defendant. So, I mean, that's a fair point, right? Because if you're filing a bogus patent lawsuit against a defendant, um, if it's a bigger entity, then they need to allocate a lot of resources in digging through the documents to make sure that to prove that they didn't infringe the patent. So that will be a lot a lot of money for the defendant. So that's why I think this isn't really fair for both plaintiff and defendant. Um, the next one is the delayed discovery to keep costs down. So this is somewhat related to the previous one, is that um, the patent lawsuits are so expensive just because that defendant needs to allocate a lot of financial resources and human resources to actually digging through the documents and all that to build the cases for the plaintiff. But they kind of want to delay that process so that they don't really they so it needs it requires a little bit of validation process before they get through to the point that they have to allocate resources to digging through the documents to build the case. And the last one is protected end users. This is particularly good about, um, for instance, if if a end consumers are actually buying this mobile devices, let's say Wi-Fi router, and they're providing the services through that Wi-Fi router, say for instance in Starbucks, then they might get sued just because if the router infringe some kind of patent and they'll get sued. But this um, this point ensures that any plaintiff cannot sue end consumers. Actually, they protect end consumers um, by making sure that they cannot sue them because they didn't they didn't make the Wi-Fi router. Instead, they just provided services for some other